was confused. Okay, all right. Yes. So just turn it around and we're good to go. All right. Yeah.
Want to set this up front?
I'm not sure. Yeah. Thank you. Okay, thanks. Bye. We're ready. We're improvising, but we're ready. Don't forget to turn your microphones on and to use them. Thank you.
Welcome, everybody. I think I've seen you guys before somewhere. As we normally do. What we'd like to do is start off with a moment of silence.
Our Father, very simply today, we ask for wisdom. The wisdom of King Solomon, who was the wisest man in the earth. We ask that you would give us also the spirit of Jesus Christ, the Savior of the world. So at the end of this meeting, we will go out of here having gotten the answer to our prayers. Thank you. In Jesus' name, amen.
Okay, so we choose a quorum, and again, we're about full house, and this is great. We appreciate some folks. We lost some folks in the last time.
And since we lost some folks in the last time, there are 3 new faces, and usually at the beginning of the meetings, we would introduce ourselves, but I didn't put that on the agenda.
Now, let's just.
Forgetting
let's
that
just
we have
all-
3 new members.
Let's all do that.
So,
So
yes.
we'll start here.
Yeah, I'm David Neal, and I'm a new alternate to the whole this year.
I'm Erin Cox, and I'm new.
And I'm Martha Chastain, and I'm
You're old.
I'm old, my second term.
And I'm Mark Spence, and I'm old, but I deny it. Robert Salaski, fifth. Did the fifth one
Yeah, you can.
there?
I'm Danny Sharp, a new alternate.
And we all know Bill, Mr. Solomon, who led us in our prayer. Thank you, Bill.
Okay, so first item on the agenda is suggest motion to adopt the meeting agenda as per presented. Has everybody seen the agenda?
Yeah.
Mr. Chairman, I move we approve the agenda as presented.
Do I hear a second?
Second.
I'm being yelled at quietly from the gallery back there who is doing the video. I apologize. Okay, we've had a motion and a second. All in favor, say aye. All opposed? Okay, why are we here today? I think the first thing to talk about is the order of approval of the special use permit, and if you would, Brian, give us a little intro.
I will, thank you. I was just trying to pull up the statutory provision that talks about, I think it's 405, 406, thank you. 406, when it talks about quasi judicial process and procedures, it talks about decisions, and I'll paraphrase and try to be brief, but it says, every quasi judicial decision shall be based upon competent material and substantial evidence in the record. Each quasi judicial decision shall be reduced to writing, reflect the board's determination of contested facts and their application to the applicable standards, and be approved by the board and signed by the chair or other authorized member of the board. Today, after many hours of hearings and a vote by a prior board with other members who have since left, there was an order drafted that reflects the board's decision that happened at the last hearing. It's accompanied by conditions that were imposed by the board at this hearing. And so pursuant to 160D 406 in paren J, this board is here today to approve that board's decision, and it's actually in effect your decision. So the idea today is we don't get to rehash the facts. We don't get to debate what was said and what happened. I sent an electronic copy of that order for everyone to review. And it's this board's duty and obligation, as it would be to approve minutes from a meeting you did not attend. It would be your duty to approve that order if it accurately reflects what the decision of the prior board was. You're not saying you agree or disagree with the decision. You can liken it to approval of minutes. All it is it's an attestation that yes, this does reflect what the prior board voted upon and approved. And so if other individuals didn't have an opportunity to talk to anyone, I can attest that the board voted to approve the MRA's application for a special use permit, but I'm also going to have the chairperson who read the order attest to that the order accurately reflects what was said and done at the prior hearings. Mark, that's you.
Okay, I attended the hearings. I reviewed the proposed order and conditions. The order before the board accurately reflects, in my opinion, that determination made by the board to approve the MRA special use permit with conditions, and conditions are accurate. So I'm attesting to that. I'd like to open up to the board for any comments.
Microphone, please.
I'd like to open up to the board for comments that you might have.
And in consideration of those comments, I think I put on your table today the opposition, who are represented by Attorney John Miller and Attorney Jamie Whitlock. They filed an objection to that order, asking this board to postpone or not approve the order until it can be more accurately reflected by verbatim transcript. But I'm just bringing that to this board's attention. We're not going to have arguments on it. No one's going to talk about it. With Mr. Spence's attestation that the order accurately reflects what happened, I think this board needs to take up a motion to approve that order with the conditions. So moved.
Second.
All in favor?
Aye.
All opposed?
And Mr. Solomon, were you yes, no, yes vote or no vote? Okay, I didn't see that. I apologize. Thank you.
Okay, so the next item is to review and consider arguments and take action regarding preliminary matters and motions related to the two applications for appeal.
So if I can just jump kind of in and tell the board what they've got at their tables. There were 2 appeals filed by Attorney John Miller and Attorney Jamie Whitlock representing their parties. The appeals that you have, again, I sent an electronic copy of those appeals with attachments. There were attachments to those appeals. I sent them to everyone electronically. I understand that some folks may have had a difficult time downloading them, although other ones said that they got them fine. I apologize. What I have copied for the board today are the appeals without the attachments. And the appeals relate to testimony from Scott Adams on December 13th, 2021. I believe is the date of the testimony. So those are the appeals. As a result of those appeals, the town filed a motion to dismiss. The applicant, well, the MRA filed a motion seeking standing and a motion to dismiss. And then the appellants, who are the individuals who filed the appeal, they filed a response. All of those, again, were sent everyone electronically yesterday. May have had some difficulty downloading them, but I've made copies of the documents themselves, again, without the attachments. So what you will be doing today, and all we're doing is hearing the legal arguments today related to that appeal and the motions to dismiss. And so I think the first order of business under this review, consideration, and hearing arguments and taking actions is that we would likely make sure that there are no ethical issues with anyone on this board hearing these motions. Then we would have to take up standing. MRA in this appeal is not the appellant, but it does deal with their property, and we can address that at the appropriate time. But I think the MRA has filed its application for standing. Once we've made a determination as to the parties with standing, then we can hear the arguments of counsel and make a determination on what to do with these 2 appeals.
Mr. Golding first.
Mr. Norm, or Mr. Whitlock?
Yeah, I just wanted to say, to the extent it moves things along, on behalf of Kate Hanger, and I believe I speak on behalf of Mr. Nord and the Jones family, we stipulate to the MRA standing for purposes of our appeals of the zoning administrator's determination. So just to the extent that moves things along today, I just wanted to make sure that was clear on that.
Thank you, Mr. Whitlock. Yes, it does. It will help. So yeah, so what we would do is we would take up this matter, ethical consideration, see if anybody has any problems hearing and ruling on these appeals. Standing's been stipulated to, we move right into the arguments of counsel.
Not only do we want to do that, but we want to remind everybody that we are in open session. We are not to talk, and that's part-time communications when we take breaks. That's very important. If for some reason we're not finished, when you go home, it's the same way. Now, anybody on the board feel like they have some conflict or ethical issues that will prevent them from making objective.
And if that's good, is everybody okay with the board the way it's constituted right now? Mr. Norm, Mr. Whitlock?
No objection, Mr. Goldman. I just, are both of the alternates serving today? Okay.
Yes.
Great.
Yes.
I just want to make sure I knew who was composing the board. Thank you.
I was just gonna, 2 things. I would reserve any objections you might have to the board participation, but we don't have any other feedback make at this point. I don't think the board here asked about whether there have been ex parte communications up until now, and just would like to clarify that for the record.
Okay, well, this question concerning the,
Well, ask it to me.
thanks. Ex parte communications about this very narrow focus that we're going to be dealing with today, is that the question?
Any ex parte communications about the appeal with
About
anybody?
the appeal.
Yes, about this issue.
Has there been any ex parte communications about? Said no.
Okay. Mr. Nor, are you satisfied? Thank you.
Okay. Let's start with the,
So I would think the appropriate way would be to start with the MRA has standing, so they're party with standing, the town whose decision it was that was appealed has standing. So between those two parties, I think that they should probably go first on their motions to dismiss because it's their motions. And so I don't know if it would be Ms. Rice or Mr. Morfis go first.
Everybody ready?
everybody's ready.
All right, let me begin by saying I did not chime in, but I certainly would, the town would certainly also consent to stand in the MRI, just for purposes of the record. Good afternoon. Some of you have seen me over several months sit here and probably wondering what my role was. My name is Cindy Rice. I'm an attorney with Patla, Strauss, Robinson and Moore, and I represent the town of Montreat with regards to these proceedings. You see me sit through the entire special use permit hearing, and now I'm representing the town in connection with the appeals. Can everybody hear me okay? So, we are here today. There were two appeals filed, one on behalf of Ms. Hayner and one on behalf of the Jones family on January 11th, 2022. And both of those appeals you have before you, and they're essentially identical in argument. Ms. Hayner and the Jones family are appealing the testimony of the zoning administrator on a particular issue from the one day of the hearing, December 13th, 2021. And the issue is the testimony he provided on one principal building per lot. Now, in response to those appeals, I have filed a motion to dismiss on behalf of the town. And you'll hear from either Mr. Morfis or Mr. Ost in a minute, and MRA has also filed a motion to dismiss those appeals. We're here today to talk about whether or not the appeals are proper and to be heard on the motions to dismiss, not to get into the merits of the appeals themselves. And I want to make sure that's clear. It means you're being asked to look at, are the appeals proper and should they be heard by the Board of Adjustment? If you decide that they should be heard, then we will schedule another hearing. We will all come back and we'll hear arguments on the merits of the appeal. If you decide that they should not be heard, then you would grant the motion to dismiss, one or both of which you're going to hear today, and that will conclude the matter. So you have a copy of the town's motion to dismiss. It's one of the many documents in front of you. It's a large, thick, stapled, I think 44-page document. You were given it electronically as well. I'm going to walk through that. Don't feel like you have to read it while we're sitting here. In fact, I almost prefer you listen as opposed to try to read it and listen to me. But there's certainly, the documents and the zoning ordinance provisions and the case law that I'm going to cite as references in that packet in front of you. Okay. But essentially, the underlying position of the town with regards to these appeals is that they are not properly in front of this Board of Adjustment and that they should be dismissed. And I'm sorry, I'm looking over this thing, so if I look like I'm doing that,
And
I don't,
it's
right in the eyesight, I don't know, he's like staring at you guys. Thank you so much, Brian.
Yeah.
So we're moving to dismiss, and we're doing so on 4 bases. This is what is spelled out in my motion to dismiss. The first is the appellants in this matter. They are saying that the testimony of the zoning administrator in the December 13th hearing was a final determination that is inappealable to the Board of Adjustment. That is not correct. That's the first issue. We do not believe his testimony is a final determination subject to appeal. The second issue is we do not believe the appeals were timely filed. The third issue is, and I'm going to say this and y'all are all going to look at me like there goes a lawyer, but it's the doctrine of collateral estoppel. What the heck is that? It's merely the idea that this issue's already been decided and they don't get a second bite of the apple. And I'll explain that in very detail. Yeah, no problem.
Slow down. Slow down.
Okay. No problem.
I'm Southerly, you're talking too fast.
Not a problem. And if I do it again, tell me again.
I will.
Okay. So I've mentioned 3 reasons. Not a final determination,
Got it,
not timely filed,
got it.
giving them a second bite at the apple, which they're not allowed to get. And the 4th reason is we're saying this appeal is premature and interlocutory. Now, I'm gonna go into each of one of those in greater detail, but I want you to know kind of big picture what I'm arguing. First, I want to be clear on one thing. Any one of those reasons is a sufficient reason to dismiss the appeals. I don't have to prove them all. Any one of those bases is a reason to dismiss the appeal. So I want to start with the fact that the zoning administrator's testimony during the special use permit hearing is not a final determination subject to appeal by the court. And I want to start with that because I think it's the most important. As you guys know, this board is convened and it has certain authority, certain things that you can do. You can interpret the zoning ordinance. You can issue special use permits. You can grant variances. You can consider appeals from the zoning administrator. I mean, they're all spelled out in the ordinance. They're all spelled out in the statute. There's no question that your authority includes appeals from decisions made by the zoning administrator. That's not what I'm trying to say. The question is, was the testimony during the special use permit a final determination that's appealable? Does that fall into that category?
Not that you're boring.
Well, I would make sure people make sure you guys are awake every once in a while.
Would you repeat that, please?
I sure can. The question is not whether or not final determinations of the zoning administrator are appealable, because they are, they're appealable to the Board of Administration, or Board of Adjustment, excuse me. The question is the testimony given in a special use permit hearing the same thing as a final determination? Okay, and that's a very specific question that I want to make sure you guys are clear on. If Scott Adams, your zoning administrator for the town of Montreat, makes a decision outside of a special use permit hearing, if he makes an underlying base determination, somebody comes in, asks for a as of right determination, he looks at the information, he makes a determination. Once he's issued a final binding written determination, that can get appealed to the Board of Adjustment. That is not the same thing as him testifying on issues in connection with the special use permit. And I want you guys to understand why. And it's because final determinations require 3 things. They've got to be final, they've got to be binding, and they've got to be in writing. And his testimony at the special use permit is none of those things. During the December 13th, 2021 testimony of Scott Adams, he talked about on cross-examination by Ms. Kainer and the Jones Family's Council, he was asked questions and talked about the issue of compliance with the one principal building per lot provision in the zoning ordinance. He gave opinions on that topic, but it was not his decision to make. It was the Board of Adjustment's decision as to whether or not the application complied with those provisions. You guys, well, some of you, this board reached a decision on the application, and in doing so, reached a conclusion on whether or not the application complied with the one principal building per lot. You made that decision. Now, part of what you might have considered in making your decision is the testimony of Scott Adams. Might have been also the testimony of other fact witnesses or expert witnesses that were presented to you. It was part of the overall evidentiary information given to you. But Scott Adams' testimony was not definitive, it was not authoritative. It was up to you to make that decision, not him. So saying that it is a final binding decision that is now appealable to the Board of Adjustment doesn't make any sense. It wasn't Scott that made the decision as to whether or not those issues, whether there was one principal building per lot and whether that was the application met that standard. That was a piece of what you decided. If you look at the zoning ordinance and if you look at the North Carolina general statutes, they specifically say that Scott's authority is, that a decision of the zoning administrator in connection with appeals refers to any final binding order, requirement, or determination. Any final binding order, requirement, or determination. If you look at the statute to define determination, it says a written, final, binding order, requirement, or determination regarding an administrative decision. Scott's testimony is not a final, binding, or written determination. There is no writing. Now, Mr. Nor and Mr. Whitlock are getting up and they're going to argue that the transcript from the hearing is writing. That's not what that means. That means when Scott issues a letter outside of a special use permit context, he'll issue a letter, he does it in writing, so that everybody knows this is a final determination by the zoning administrator. And if you practically think about it, that makes sense. Otherwise, every time your zoning administrator opens his mouth, he would be subject to having someone to appeal his statement, any oral statement he gives to this Board of Adjustment. It's going to result in a whole lot of appeals and a whole lot of cost and expense to the town. And practically speaking, that's why I have filed a motion to dismiss on behalf of the town. Is that argument doesn't stand with the way these proceedings are supposed to work. I think in the context of a special use permit is the real key piece here. This is not Mr. Adams giving a written letter of determination about a specific issue that a town member asked him. This is not Mr. Adams reviewing something. This is testimony in connection with special use permit hearing in which the decisions are made by the Board of Adjustment. And so I want to make sure everybody's clear. It's not final, it's not binding, it's not in writing, and therefore it's not a proper final determination before the Board of Adjustment. So that's my first point. It's not a final determination. It can't be appealed to the Board of Adjustment. It's got to be dismissed. Now, in looking at this particular issue and in going through, trying to figure out how to explain this to you guys and kind of understand the legal arguments that I'm trying to make. One of the sources that I kept going back to is, well, how do I equate this back to what Scott does every day? And the reality is, if he makes an oral decision to someone over the phone, they can't appeal that to you. And it's the same thing. If he makes oral testimony in connection with this special use permit hearing, you can't appeal that to this board. So, argument number one. The second argument is that the appeals were not timely filed. So, in the appeals themselves, the essential argument is Scott Adams made a final determination. We're now appealing that to the Board of Adjustment. The only final determination that Scott Adams made in connection with the MRA's special use permit is the determination that the application is complete and that the application should be submitted to the chair for the Board of Adjustment to consider. That's the only final determination he made. And that final determination was made in the summer of 2021, July, August. The statute specifically says, and the ordinance both specifically say, that appeals have to be brought within 30 days of a written decision. If that's the only final determination he made, that appeal should have been brought long before January of 2022. Yes,
I have a question.
sure.
Chairman, my,
Help me understand this, okay? So he gave his written determination in July.
The written determination that the application was complete.
Correct. Okay. So how could Ms. Hayner and Mr. Jones make if they had not heard his testimony, how could they not be timely? They wouldn't be timely until after they heard his testimony, which was in December.
Two different issues. So what I'm saying is, first issue, his testimony is not a determination. It is not a final determination. The only determination he made was that the application was complete, and that's what occurred in summer of 2022. Does everybody follow me on that? 2021, thank you. Still feels like 2021. I think I get it right. Does that make sense? It's not that I'm saying the testimony was back in the summer of 2021.
I understand.
Okay, perfect. So that's my second argument. First one is it's not a final determination. Second one is it's not, if there was a final determination made, It was when he approved it to go up to the Board of Adjustment, the application itself, and that was made back in the summer, and these appeals are not timely.
And was everybody aware of that? Would they have seen that work on July 30th? Is that available to people?
So that was part of what gets submitted with the application.
Which means it's public document.
We would object to the characterization of knowledge that our clients have being represented by.
But the charge-
Fair enough, fair enough. The only thing I'm trying to say is, if you recall, the special use permit hearing started in October. So if they didn't have any notice before that, they certainly had it in October that it had been submitted and as complete, because it doesn't go to the Board of Adjustment until the zoning administrator has signed off on it. Does that answer your question?
I just want the board to be clear, and I apologize, Ms. Rice, I don't mean to interrupt you, but, and I'll address this in my argument, but a determination that the application is complete is different from a determination that the proposed use complies with section 605 of the ordinance.
Absolutely, and Mr. Whitlock is correct, I'm not trying to equate those two things. I'm merely saying, to the extent any final determination was made by the zoning administrator, it was to send that application up. I'm not trying to equate the two. Okay, so those are my first two arguments. My third argument, and you heard me say these words, and I'll try not to say them again, it's the doctrine of collateral estoppel. That is the idea, in a non-legal sense, that you cannot have, well, let me put it a different way. It's the idea that once an issue has been raised and decided by a court, or in this instance by a Board of Adjustment, that the parties cannot then not go back and have it relitigated or reheard to try to get a different outcome. It's pretty simple. You don't get a second bite of the apple. You don't get to raise an issue in the special use permit hearing, and then when you don't like the outcome, raise it again on appeal back to the very same organization, the very same Board of Adjustment. The reason for that is you don't want repetitious lawsuits. You don't want repetitious hearings. You don't want to waste the time and resources associated with essentially trying to get what you want a second time. In North Carolina laws, it specifically says that collateral estoppel, or this notion of the second bite at the apple, you don't get a chance to have the Board of Adjustment reconsider issues that have already been decided. And as we said, on January 6th, this board, as it was composed then, voted and approved the MRA's special use permit. Earlier today, this board, as it exists today, approved the written order. And in doing so, you decided the application was going forward, you approved it. And that means, in order to do that, that you also signed off on the issue of one principal building per lot, and that it complied with or met the requirements of the zoning ordinance to go forward. So this issue was decided by this board in connection with the prior hearing. So to bring it back before this board again in the form of an appeal is giving the appellants two bites of the apple, if you will. And that's not allowed. Simply put, I would say Ms. Hayner and the Jones family had a full and fair opportunity to be heard on this particular issue in the special use permit hearing. They were heard on the issue extensively. They were able to cross-examine witnesses, bring their own witnesses, fact or expert. They were represented by the same counsel who's now bringing the appeal. The issue's been decided, a final order has been entered, and to be clear, they can't come back and get that second bite at the apple. Now, that doesn't mean they're not without remedy, and I want to make that clear. There are statutory appeal rights. If the appellants or the MRA, the applicant, do not agree with the decision made in the special use permit hearing and the order just entered by this board, they have the ability to appeal that to Superior Court. That's a statutory right. So it's not that they're losing all their rights, it's just this is not the proper venue to have that heard. That's my third argument. So we've got, it's not a final determination, it's not timely filed to the extent there was a final determination. They don't get a second bite at the apple, or you can call it collateral estoppel if you want to do that. And the fourth argument is pretty simple. It's just, this is a premature appeal, it's interlocutory. As I said before, they have a statutory right to appeal this matter to the Superior Court. And that's what they should do if they want to challenge the decision made by the Board of Adjustment or any of the underlying decisions that were made, including the determination that it complies with the one principal building provision of the zoning ordinance. So, yeah, they're not obligated to appeal, but if they want to, they have that remedy available to them. And if you allow this appeal to go forward and be heard on its merits, it's premature. And it also sets up a situation where you've got an interlocutory appeal that can come up with two different outcomes. You can have the Board of Adjustment ruling that the MRA's application is okay and complies with that provision. You could arguably then have a second different opinion if you were to rule on the appeals differently now. That's not what the courts intended. That's why they don't allow interlocutory appeals. If this is going to be appealed, it should be appealed to the Superior Court. And that's the gist of it. And so I'm beating you on death with this, or beating the dead horse, whatever you want to say it. But the four things are, and the reason you should dismiss these appeals, it's not a Scott Adams' testimony as the zoning administrator during the special use permit hearing. It's not a final determination. It's not final, it's not binding, it's not writing. To the extent that he made any final determination, it was made in the summer of 2021. It's not a timely appeal. They weren't filed until January 2022. Third argument, they don't get a second bite of the apple. They didn't like the outcome from the first hearing. They don't get to now bring it back as an appeal to this board. And the fourth argument is it's a premature appeal. If they want to appeal it, they can appeal it to the Buncombe County Superior Court by law, by statute. So we would ask on behalf of the town that this board dismiss both appeals. Any questions? Anything I can answer? You already heard from Mr. Morpus, Mr. Oates, and as well as the appellant's attorneys, but I'm happy to answer questions if you have them for me.
I think I have a question. I want to understand the appeal needs to be timely filed. And the statute says the appeal has to be filed within 30 days of a written decision.
Exactly.
When was that written decision? What was that date?
Yeah, so fair enough. So my argument is that the testimony of Scott Adams during the hearing on December 13th, there was no written decision. It was testimony. Now, was a stenographer here and keeping a record and a transcript of it? She absolutely was. Can that be transcribed? And did the appellants have it transcribed? They did, but that's not the same thing as a written decision. You know, a written decision implies that Mr. Adams has signed off on something, that he has made a final determination, put it in writing. And the reason for that is so everybody knows this is the date from which the appeal starts. And so I would argue with regards to his testimony, there was no written decision.
I think I understand that argument. What I'm trying to understand is the written decision that the Board of Adjustments
Sure.
made
Sure.
is, I think, the intent of the statute. If I'm of the 30 days.
The written decision of the Board of Adjustment?
Yes.
Okay, yeah, so slightly separate question. If you're asking about their ability to appeal the decision that was just entered, the order that was just approved?
No, not that one. The one, yes, that one. Sorry.
Okay, so there's three things. There's the testimony, which we just talked about, there's the order that was just entered by this board. And they do have the ability to appeal that order, and they have 30 days from the order being entered today. Okay, that's the appeal to Superior Court. Sorry, stop using the microphone. That's the appeal to Superior Court. And I didn't mean to confuse things with the notion of the zoning administrator's decision to allow the application to come up to the Board of Adjustment. I was merely saying that's the only final determination to be made. That decision was back in the summer, July or August, and it would have been 30 days from when that came to the Board of Adjustment. So those are the three sort of timelines. Does that answer your question?
Thank you.
Okay, so let me ask another question, different ways, I think might be the same answer. So if either one of these account, either side didn't like our decision or wanted to appeal the decision that we made back in January, if they would have filed anything with the Superior Court between January and now, it would fall under that number 4 again, correct? Because the certain decision was made today.
So there's nothing that has been appealed to the Superior Court.
I think if they wanted to,
If they wanted to, they would have to wait until the order was entered
which was today.
today, and now they can appeal.
So if they would have done something prior to today, it would have fallen under number 4 again, correct? Meaning that it was premature.
Yes, correct.
Okay.
Correct.
that's what
I would have made that argument. Yes.
So
you're
today
exactly
is the
correct.
first of 30 days.
Correct.
Okay.
Submitted To today being the first of 30 days, it's.
Or whenever approximately.
I'm going to try and keep my comments relatively brief. We agree with everything that Ms. Rice said, and I will say before I get going, Mr. Noor is correct. There's a statute that talks about when the effective day is, and it's 30 days from that, so anyway, so we raised a lot of the same arguments in our brief motion to dismiss that Ms. Rice has raised, and I won't repeat them. I really have just 2 points that I want to add. The first is we believe that with the adoption of the order today, the opposing counsel's appeals are now moot. And when I say moot, I mean that there's no longer an issue before you. Under North Carolina law, if there is a lawsuit that's been filed and it is mooted, the court can no longer rule on that case. You don't issue advisory opinions on issues that become moot. And the reason I say that applies here is because as board members who were here before know, and I'll read for new members, you have the authority to modify standards in the ordinance. So let me just go through that. This is really for the benefit of our new members. Zoning ordinance 310.622 says that the use meets or will meet all the required and applicable development standards and conditions of the town of Montreat. And then there's some more language, and it concludes by saying, except as such regulations may for each case be modified by the Board of Adjustment. Now, there are some findings of fact in here that are applicable, but I'm going to just read to you your conclusion of law number 3. What it says is the board has authority to modify applicable development standards pursuant to section 310.622 of the ordinance, or to waive application of a development standard in certain special use permits pursuant to section 107 of the ordinance. The requirements of section 605, 606, and 705 are modified to allow a hotel with one or more buildings and more than one principal building per lot, or 2 accessory buildings per lot in a residential zoning district, as the case may be, and to allow perpendicular parking. So for new board members, and I think the appellants have explained this well in their appeals, they're saying that Mr. Adams was wrong when he said that section 605 of the zoning ordinance does not apply. And that's the part that says you only have one principal building per lot. And what I'm saying is that assume the appeals are properly filed, and assume for a minute, which of course we disagree, that they are correct on the law, that Mr. Adams was wrong. Just assume that as a hypothetical. You have waived this requirement. It no longer applies to the Mountain Retreat Association in this project. And so we would argue that the appeals are not proper because they've been mooted. So that's our first argument. The second point I want to make, and I hate to disagree with Ms. Rice, because I think she really explained the law well. But we would say there was one earlier appealable determination or final determination that is at play here. And if you recall, some of this issue came up from the fact that the project has a single lot, but there are 6 existing buildings on the property. The MRA is proposing to demolish 3 buildings and replace it with one new larger building, which would leave 4 buildings on the property. However, in March of 2020, the town planner, Adrian Eisenhower, at the time approved a combination survey for the MRA. What that did is it allowed the MRA to combine 4 separate lots into one lot. And so I don't think the question was ever put to Planner Eisenhower, well, does this comply with 605? I'm not implying that, but he did allow one lot with 6 buildings. So I believe that that is a final determination that that approach complies with the zoning ordinance. Now, in the brief that Mr. Noor and Mr. Whitlock have filed, they said, well, even if that were true, we haven't had any actual constructive notice. Actual notice means that someone has mailed or hand delivered a notice of a decision to you. We would agree that there was never any kind of notice of the plat recombination. That's not something that typically happens. However, we disagree about the constructive notice. We filed our special use permit application last summer, and obviously they understood enough about this issue that they were asked detailed questions in December of last year to Mr. Adams about section 605 and this issue of principal buildings on single lots. And I couldn't tell you the exact time that they had constructive notice, but I think that if they had wanted to appeal this decision, it could have been done well in advance of the special use permit hearing ever being heard. We would take the position that there was a final determination and that plat was approved. So those are our two additional arguments. And I'm happy to answer any questions that you might have.
So the disagreement here is that is the technical consideration that it was in December. The appeal was filed in January, but really it was before December that this happened. This was this.
That would be our argument, that by approving a combination survey, you're saying multiple buildings on a single lot complies with the ordinance.
Okay, the actual versus what was the other thing you said?
So there's the issue of actual versus constructive notice. Again, actual notice is, the town planner mails them a notice of a decision being made. That did not happen. Constructive notice is that you at some point find out about it. This is, I saw the notice of zoning change sign in the yard. Or in this case, we'd say you have a special use permit application that's filed as a matter of public record.
Oh, okay. Okay, so you're saying, I think, that if it's not been constructed, the buildings have not been constructed. Help me,
Okay, are we talking about constructive notice?
I'm talking about, yeah,
Or are we talking about the other issue about what does it mean to combine 4 lots into one?
well, they've already combined 4 lots into one.
Yes, ma'am, that's correct.
Okay, so we're still back to the 1 building per lot.
Yes, ma'am, and I'm not,
That's gonna be the hotel, right?
yes,
Yes. Okay, so that's the hotel. Got 1 lot, 1 principal building. Fine. What about these other structures? You going there? I know you are.
well, let me be careful because, and I think Mr. Whitlock said this, and I want to respect that. Actually, it was Rice, we are not getting into the merits of the arguments today. If you all deny the motions to dismiss, then we'll have a separate hearing on these appeals. So I don't want to get into that, but I think we would take the position, to answer your question, ma'am, that this board has now specifically allowed multiple buildings on a single lot. I think that's what the conclusion of law number 3 does. And we would take the position, because remember, Mr. Adams said that it already complies with the zoning ordinance. We take the position, when you authorize that survey that combines 4 lots into 1, you have to be saying that you're allowing multiple buildings on a single lot, because that's the effect. And otherwise, you'd be saying that we're going to allow you to do something that's illegal in our ordinance. So that's what we're trying to argue.
Okay.
Thank you, Mr. Chair. Members of the board, it's good to see those of you who are back again for another run. I'm surprised some of y'all came back after what we put you through over the last months of 2021 and early 22. But nonetheless, nice to see you again. It's also nice to see the other members, some new and some alternates who are here tonight. My name is Jamie Whitlock, for those of you who have not had the chance to meet. I'm an attorney with Davis and Whitlock, based out of Asheville. And I represent Mrs. Kate Hanger, who owns the property at 319 Assembly Drive here in Montreat. I wanted to thank Ms. Rice and Mr. Mortis for their arguments, both very well stated. And like Mr. Mortis, I'm going to try to be pretty brief and try to explain our position, which, as you can imagine, differs from the position of the town and the MRA. Just as briefly as I can, of course, welcome any questions from the board once I'm finished. One initial point I did want to make, and this is just a clarifying point, Of course, nothing pejorative toward Ms. Rice. Ms. Rice, in her capacity here today, is of course, here is her attorney for the town and is an advocate. And I think the board knows that, you know, she is advocating on behalf of the town. She is not your attorney here. And so just wanted to make sure the board knew that.
Brian will remind me of that.
I'm sure he probably, that's why Brian's sitting there. So, and again, just, that's all technicalities, but I think important nonetheless. Before I get in, as Mr. Morphy said, I think Mrs. Rice has kind of laid out the kind of the arguments here. I'll try to address those as she laid them out for the convenience of the board. I think it's important that the board distinguish, kind of set aside for a second, or distinguish between the order it just entered and Mr. Adams' December the 13th, 2021 testimony and the final determinations that he made in that testimony. Just for the purposes of this argument, all this appeal that my client and Mr. Nor's clients have filed, let me also just back up for a second and say, because our appeals are substantially similar, I'm going to try and make most of the arguments on behalf of both Kate Hayner and the Jones family and Mr. Nor's clients. If Mr. Nor wants to add anything at the end, he's not shy. He'll speak up if he's not happy with everything I said. So, but I am going to try to address the arguments for both parties since the appeals are substantially identical. So again, I just want the board to just, again, the question before the board right now doesn't have anything to do with the board's order. It just ended. We are looking at a narrow issue of what we contend are final binding determinations that Mr. Adams made in his testimony on December 13th last year. Okay. First, as to whether or not that was a final decision, we certainly contend that it was. Let me first address the writing portion of that. I certainly disagree with Ms. Rice that there is any requirement under North Carolina law that in order to be a final administrative decision appealable to the VOA, a determination has to be in writing. The only potential requirement here for a writing is found in the Montreat zoning ordinance. And just to make sure I'm citing the right thing here, section 304.1 of the zoning ordinance says any final determination shall be recorded in writing. As all this board knows, in particular the members who were here throughout the 50 plus hours that we met over the MRA's special use permit request, all of that testimony was recorded in writing by a court reporter. And as Ms. Rice noted, we did in fact have that reduced to writing and submitted along with our brief in this matter. Just to show the board that it is in fact in writing. But more importantly, it was, at the time the testimony was given, recorded in writing. That is the exact language of the Montreat zoning ordinance. And again, I do take issue with Ms. Rice's statement that there's any other requirement under North Carolina law that a final determination be in writing. And we set this out in our brief, and I know the board has those, and I don't know how much time you've had to look at them, but what North Carolina courts have said when they have reviewed, when determining what is a final appealable determination, it's the substance of the determination. It's not the form. And I agree with Ms. Rice that certainly you don't want every oral statement that a zoning administrator or a planning director might make to somebody on the phone constitute a final binding interpretation. However, what we're talking about here is sworn testimony under oath. There's, you know, any change, you know, there's no question there of notice or evidentiary reliability. Everybody that was there that night heard that testimony. They knew when that testimony happened. It was, again, as I mentioned before, it was recorded by a court reporter. So, you know, that's the purpose of a writing to the extent there is a requirement in the Montreat zoning ordinance. It's for notice, and it's later on for evidentiary reliability, so you don't get into a he said, she said about what the determinations were. It's all very clear. It was recorded, it was sworn testimony offered in public, in a public hearing, and in fact was recorded in writing. Now, kind of back to the case law again, as I mentioned, substance over form. What the cases say, and the cases cited in our brief are the exact same cases that the MRA and the town rely on and included with their submissions. And it's essentially kind of three-pronged test as I kind of look at it. But it's that an affected landowner requests an interpretation of the zoning ordinance as applied to a use. And that's the first part. Second, that request is made to a local official empowered to offer an official interpretation of the zoning ordinance. And third, that local official exercises that authority and provides a formal interpretation. If those three things are met, it's our position that is a final binding appealable determination. And that is exactly what happened here. On December the 13th, Mr. Adams, while testifying, the appellants, Kate Hayner, the Jones family, Mr. Nor and I, on their behalf, we requested his interpretation of the zoning ordinance in section 605 in particular, and compliance in whether or not the MRA's SUP application proposed use of that property complied with that. Now, under, I believe it's section 109 of the zoning ordinance, it provides the zoning administrator, here Mr. Adams, is charged with the responsibility for interpretation, administration, and enforcement of the ordinance. He is empowered to offer that interpretation. And so the second element is met, would be our position. And then finally, in response to our questions, he offered his interpretation of that provision was satisfied. So I think all the three factors that the cases look at are met here. And it is a final binding appealable determination. It is in writing. Everything is met under that first kind of factor that Ms. Rice mentioned. On the timeliness of it, both North Carolina statutory law, chapter 160B, which we've all heard so much about over the past few months, and the zoning ordinance, section 310.4C, it says any person withstanding has 30 days from receipt of actual or constructive notice. Mr. Adams' testimony on December 13th was the first actual or constructive notice to Ms. Hayner or to the Jones that Mr. Adams interpreted the zoning ordinance in this manner. Therefore, we filed our appeals. I think they were filed January the 11th. I have to look back. They were filed within 30 days of December 13th. So certainly we contend, given within 30 days of actual or constructive notice, that was the first notice of any kind that Mr. Adams interpreted the zoning ordinance to allow for the MRA's proposed use of property. So the appeals were in fact timely filed. Now, as to the third and the fourth issues that have been raised, the collateral estoppel and whether these appeals are premature. This goes back to my statement that I think the board needs to separate the order, the final overarching order it just entered with this narrow appeal. Given that these were final binding interpretations and we timely appeal them, we have a right to that appeal. And, we also, as I think Mr. Morphus and Ms. Rice correctly pointed out, we have a right to appeal this board's order to the Superior Court, but not an obligation. And so, but the question before this board right now isn't whether, it doesn't concern that right to appeal the Superior Court. This is on the narrow issue of our right to appeal Mr. Adams' final determinations. Again, I think it's a very simple question or a very simple answer. Is we have a right to appeal that, given that we timely filed appeals from actual or constructive notice. With that, I think that's all that I have right now, and appreciate the board's time. Thank you.
Sure. I'll be very briefly. We intentionally joined our arguments in order to conserve time for the board. There are just a few things I want to highlight. On behalf of my clients, we would incorporate all the arguments made by Mr. Whitlock on behalf of the Joneses for the record. Separate and apart from the written determination, I just want to direct the board to 160D405, the actual language there. The language says, except as provided in 160D1403.1, appeals of administrative decisions made by the staff under this chapter shall be made to the Board of Adjustment. And then it goes on. Administrative decisions. Okay? That's a term that's defined. Let's go to what the definition of that term says in this section. And it says, administrative decision, this is 160D102. Decisions made in the implementation, administration, enforcement of development regulations that involve the determination of facts and the application of objective standards set forth in this chapter for local government development regulations. Doesn't say anything about writing. Nothing. The next sentence says, these are sometimes referred to as ministerial decisions or administrative determinations. It's kind of like I'll use an analogy. Vehicles. Under the category of vehicles are cars, trucks, and SUVs. Administrative decisions might have a written determination. You might have the other things that are in the definition. And decisions about implementation, administration, or enforcement. All different things that fit under the umbrella of administrative decision. The only part of the definition that talks about in writing is the definition of determination, not administrative decision, determination. And it says a written, final, and binding order requirement of determination regarding an administrative decision. Okay. It falls under the umbrella, but it's not everything that's under the umbrella. Mr. Adams' testimony was an administrative decision under oath in front of this board. That's the first time we got the notice of it, and we appealed it to make sure that we're preserving our rights to appeal that and the rest of the whole package as part of this process. Because what we don't want to do is end up, as Mr. Morpus said, we don't want to end up missing an appeals deadline that then keeps us from raising important issues and trying to Superior Court. And so that's why this is before we go.
Your voice is dropping.
I apologize. That's why we appealed it. We want to preserve all of our clients' rights. We feel like this is appealable to the Board of Adjustment. We ask you to do that. Okay. Any questions?
You guys didn't know, the attorneys didn't know prior to Scott saying that he made that you had no idea that he made his judgment based on or a verbal, he made some verbal statement. Did you know that prior to December 13th?
So, I want to note a couple of things. One, the legal standard is our client's knowledge, not their attorney's knowledge. And two, I don't want to get into issues that might be covered by other privileges, and I'll ask Brian to potentially weigh in on this. I can speak for myself in that I don't think it's appropriate to ask an attorney on behalf of their client what they knew, as it might require us to disclose information that's privileged. I just don't think it's an appropriate question for the judge, unfortunately.
And what I don't want is to get into the merits of the underlying appeal. What we need to focus on is what the arguments were and what was stated in those arguments.
Okay.
Whether or not what John told his client, I mean, you can't ask or he shouldn't tell you confidential information.
I'm legally prohibited from doing that. And so I don't want to get in a position of disclosing something that I cannot do with not acknowledging it one way or the other and saying I can't answer the question.
Okay. Question.
I will remind the board, if they don't have any questions, and feel free to ask all of the questions, but I do want to just remind the board of a few things when you're done having all your questions answered.
When we're done,
When you're done asking all your questions.
Okay. Then.
So again, I'm not advocating one side or the other. I'm just reading from the statute as Mr. Moore had done. And we did earlier today, under 160D 406. This board, every quasi judicial decision, and then I'll put in my caveat, that's what the 8 days of hearings were for the determination of the MRA special use permit. Those were quasi judicial hearings. In those hearings, you gather facts. It is the board's determination, and I'll keep reading, right? Every quasi judicial decision shall be reduced to writing, reflect the board's determination of contested facts. You weigh the facts that is presented to you through evidence or documents and exhibits, right? And those contested facts and their application to the applicable standards. And that order is approved by the board, and that's what we did today. And those facts, as stated in that order, the facts that were presented to you at those hearings, as stated in the order, were weighed by you, and you all made the final determination on the MRA's application. You based your determination on facts that were presented to you. And so that would be, there's other provisions I can read from the statute, but that ultimately is what your decision was. You all gathered the facts, weighed the facts to the applicable standard, and made your determination. And that's reflected in today's order, approving them with those conditions.
This question, with the approval of the law. All right. With the approval of the order, the board made a legal conclusion that the application satisfied the technical requirements of the town ordinance. Is that your opinion?
Yes, conclusion of law number 3 that Mr. Morphus read. And conclusion of law number 6, the proposed use meets or will meet all required or applicable development standards and conditions of the town as such regulations have been modified by the board. So you all made that conclusion of law that the application satisfied all applicable development standards.
Okay, and for the MRA in the town, Scott, through his testimony, did not make a conclusion. This board did. Is that correct?
That is correct. That was my argument, that there was no final determination made by Mr. Adams through his testimony. The decision was board adjustment, and the decision was made by you in approving the special use permit application.
And just to tag on to that, obviously the board approved the special use permit, but it was within the board's power to deny the application as well. So what Mr. Adams said in December was not binding on this board.
Is there, I'd like to hear from you guys.
We would disagree in that he gave an opinion which he said applying the facts, the specific facts in the case to the law. This is my interpretation.
y'all are whispering.
I'm so sorry. I'm trying to be a little louder.
Y'all too.
Kiss this mic, I guess, that's what I gotta do. Mr. Adams took the specific facts that were presented in the application, applied them to what he considered the law, and gave a conclusion under oath. Okay? He also did that in the context, as an administrative decision. That's different than a development approval. Okay? Two different defined terms. He made his decision under oath. We're appealing that decision. And we think, whether the board listened to that decision or not is kind of is separate and apart from the decision he made. That was what he testified to. He said, this is my understanding. This is how I interpret the facts and apply it to the ordinance. It is my interpretation that it's a principal building and 3 accessory buildings. That's what he said earlier. And I would just add, again, I think it's very important. He is the individual as zoning administrator expressly empowered under the zoning ordinance to interpret the provisions of the ordinance on behalf of the town.
But he also is required to bring it to the board. Is that correct?
Not always. Not always. It just so happens, this testimony took place in the context of a public hearing on a special use permit. But again, I don't think that's of any influence. That just happens to be the facts of this instant appeal, where notice of the determination was delivered, and hence where our clients received notice of the determination.
And if I may, I think that is a key point. This was not Mr. Adams making a decision isolated of his own authority. This was Mr. Adams testifying to give you factual information for you, the Board of Adjustment, to then make a decision. And Mr. Whitlock is saying, he disagreed with my statement that essentially it was the Board of Adjustment's authority to rule on matters of interpretation of the ordinance. He cited section 109 of the zoning ordinance saying the zoning administrator was charged with that authority. But if you look at section 310.1 of the zoning ordinance, it specifically gives the Board of Adjustment the authority to rule on matters of interpretation of the ordinance. And the reason is you're the only ones that can rule on a special use permit hearing that is outside of Mr. Adams, your zoning administrator's authority. He can testify, he can give you his opinion, he can answer questions, but he cannot rule on that. If he could, there would be no reason for the matter to come before the Board of Adjustment.
And Ms. Rice, and just to be clear, I think 310.1 is the provision for appeal of the zoning administrator's determinations to the board, correct?
I believe that is correct.
I just want to make sure the board is
What, did I
clear
say
on it.
something else?
You said 310.1 gives this board, and I don't disagree with that, the power to also interpret the ordinance, but that's in the context of appeals from Scott, from the zoning administrator.
No, I actually think that is in the context of the overall zoning Board of Adjustment authority under 310.1. Sorry, I was afraid I
That's
misspoke.
okay. That's okay.
And why is that in the context? I need to understand why.
Yeah, so essentially in 310.1 of your zoning ordinance, it says the zoning Board of Adjustment shall have the authority. This is the authority, the things you can do or you can't do, right? And you can grant variances, you can issue special use permits. And the point I was making is it explicitly says you can rule on matters of interpretation of the zoning ordinance. And I was just trying to make a distinction. Mr. Moore and Mr. Whitlock were saying that is the zoning administrator's job. That falls within their authority. And it's true, in some contexts, the zoning administrator has that authority. But in the context of a special use permit, that authority falls to you to interpret the ordinance. And that's why I say the fact that the testimony was given in connection with the special use permit hearing matters. Doesn't matter that it's under oath. It matters that it's a factual testimony to you to consider, weigh, just as any other evidence, and then make your final decision. I think Mr. Morpheus's point was a good one. You could have chosen to rule the opposite direction and gone against what Mr. Adams said. You could have taken a different and said it doesn't meet those requirements, and you chose not to.
Question, clarifying. Is there any case where does every special use permit come before the Board of Adjustment and based on our ordinance?
In
In Montreal.
In Montreal?
Montreal,
Yes.
yes, every special use permit will come before this
Okay.
board.
So the commissioners, the zoning, we're the ones that make the determination on special use permits. No one else has that authority in the town of Montreal.
Correct.
So I'm gonna ask our attorney before I shoot my mouth off. What if he was right or what if he was wrong? Then what?
Are you asking me that?
Can I ask that question?
Just
Can you- Yeah.
I'm asking, I pose the question to you. Can I ask that question before I ask the question?
And your question is, what if he was right, what if he was wrong?
Yeah, okay, so let's say he said
That, because, so,
He said he
no,
didn't say it. He said he
the
didn't say it.
answer is, the testimony that's given is factual in nature. You all weigh those facts. You all make a determination of whether he was right or wrong. Mr. Solaski just said, is it your duty to make that determination? I thought I said, yes, it is. You all are the only ones that have the authority and the ability to weigh facts that are presented in a special use permit here. And you have to decide, was he right or was he wrong, based upon what the testimony was. And as I recall, there was counter testimony. You all weigh those facts.
I do remember weighing those facts and doing a lot of research and studying through all the statutes and coming to my own decision about how that affected our decision as a board. But I think we're in the weeds. I think we're where we would be if we didn't grant if we move to dismiss or whatever. You see what I'm saying?
Yeah, you're saying if you, I think I see what you're saying.
We're in deep enough.
Yeah, if we said, no, we're not gonna grant the dismissal and we're gonna hear the appeal again.
You
We'd be doing all of this.
you would be taking testimony again
Okay.
from witnesses, weighing the facts that are presented at that hearing to make a determination as to was he correct or was he not.
And I think we'd have to object. I mean,
And I'm not gonna, Mr. Moore, and I apologize, they're asking me legal questions. If you don't like my answers, that's fine, but I'm not gonna let I'm not gonna let you interrupt my
Well, I would
questions.
request an opportunity to lay my objection for the record at the appropriate.
You can do that at the appropriate time.
Okay, I'm just saying, are we being appropriate in the depth that we're getting into this?
I think some of the questions are appropriate. The issue is on this appeal, there was motions to dismiss that were filed based upon the legal arguments that were made. Should these appeals be filed for one, two, or all of the reasons, or none of the reasons? Thank you. Mr. Moore, you can raise your objection now.
My objection would be the characterization of what the board's process for reviewing an appeal would be, as though they would be taking additional testimony that the decision has been made. The appeal is to review the actual decision that was made and determine whether it was correct or incorrect. That's the entire reason filed the appeal. It's not hearing it new, it's evaluating the decision that was made. That was our objection. It was a mischaracterization of what the board did.
Mr. Chairman, because the remedy is a superior court. I move that the Board of Adjustment move to dismiss this appeal.
Second.
Discussion?
Mr. Golden,
There was a
the motion
motion.
was made in the context of the appeal. There are two appeals.
So,
Okay, thank you, Mr. Nora. Yes, the two appeals before the Board of Adjustment, if you want to modify your motion.
And it, for both motions, wait a minute. Dismissal was from both of you, yes, both parties. Yeah.
So if you just want to modify, or if we can just,
If I can just remember the names, is it Jones and Hayner? Is that it?
Jones and Hayner.
Yeah, yes. Move to dismiss the motion. Or grant the motion to dismiss.
Second.
okay. There has been a motion to dismiss in a second.
I suggest that we hold the board.
Okay, I think that's a great idea, instead of just saying it, so I'm holding them. Questions, opinions?
I mean, just as to how we vote.
yeah, how you vote?
Start down there. And
Go ahead.
What my vote is?
Yeah.
I say yes to the denial of the appeal for both families.
It would be yes to dismiss the
Yes,
appeals.
there you go.
Thank you.
Very good, thank you.
Yes, so the motion to dismiss.
yes to the motion to dismiss.
Yes, to a motion to dismiss.
No to the motion to dismiss in the interest of truth.
Truth.
Fairness. Hearing.
We're just moving on.
I don't want to be shut up against, I'll be quiet. Yes, to the motion to dismiss.
And I also say yes to the motion to dismiss. Now, we also have a second. Brian, help me out here. This is objection to proposed order.
That was already addressed in what we did is when I brought that to the board's attention that before we approved that order, that there was a motion, an objection, or I guess it was an objection to the proposed order. I didn't allow any comment on that. I just didn't feel it was appropriate at the time. It was the board's duty to approve.
In an effort to, before I close, is there anything else? I have been very careful. I want everybody to have their peace within. Is there anything else that needs to be added? And we specifically talked about item A and B on the list, on the. Right, we're done.
Other than a motion to adjourn.
You have questions? Do I hear a motion to adjourn? Second? We're done. Sarah.